Good morning, good afternoon, everybody, and Merry Christmas Eve. I think I got that right. Four Eves. 4 days before Christmas or so. So Merry Christmas, Happy Holidays. We're gonna have some fun today as you sit at the dinner table for Christmas. My goal today is to give you different talking points to bring up should the topic of probate come up? Should the topic of death come up? It's funny every time, not funny, but it's weird sometimes. Every time I get together with my grandparents, somebody has died and somebody's going through the process of a funeral. Unfortunately, we get old enough and our friends die, and that's what we experience through the eyes of our grandparents and parents, I guess, as you get old enough, like me now. So, anyway, probate is a topic that I don't think is talked about enough. Unless somebody has just gone through it, then it's, like I said in the video earlier, tattooed into their minds here. So, before we get going, can everybody see me and hear me? So, tell me in the chat pane down below, can everybody see me and hear me as we get ready to go into part two of our, I would say, 5 to 8 part series on estate planning. Estate planning in 2026 is just going to become bigger with what's happening in 2026. But even outside of 2026, and if you're wondering what I'm referring to with 2026, I'll get to that in a bit. But even outside of that, estate planning is about so much more than just trying to avoid estate taxes, which only a tiny, tiny, tiny group in the country today really care about estate taxes because they don't have $27 million as an estate. What's happening in 2026? Well, those exemptions are going to around half of where they are today. So that's why I keep referring to 2026. But there are opportunities, as we discussed last webinar, to utilize the higher exemptions today in preparation for the drops that are going to happen in 2026. You can think of it kind of like a sale at Best Buy, right? Today, estate taxes are on sale. You can leverage the high exemptions today, and the IRS has said that once the sale is no longer, i.e. 2026, that it's not like they can recapture what you saved on taxes, right? Best Buy is not going to come back to you and say, yeah, it's a day after our sale. Since our TV prices have gone up, you owe us a little money since you bought it for half price or whatever when the sale was going on. The IRS has said that if you leverage today's gift exemptions as well as, gift exemptions by giving away today versus dying with it after 2026, the IRS has said that they're not going to effectively recapture what that estate otherwise would have owed in estate taxes. All right, so it looks like we have everybody that can see me, that can hear me. So 4 different things here from a housekeeping standpoint. I always go into housekeeping first, naturally. Thank you, folks. Thank you for the business. We're going to finish the year at around $50 million in annuity production. My company has only been in existence for about 5.5 years now. And to get to $50 million smartly, meaning I didn't just open this company and hire a gazillion staff and say, hey, we're going to get to $50 million year one. No, it's been smooth and steady. Why do I want it to be smooth and steady and ultimately get to $1 billion in production? Smooth and steady, because my number one proposition for you fine folks is service. Most of the time when you deal with my company, you are dealing with me directly, the owner of the company. And that's what's gotten us here to $50 million today. And I, as the owner of the company, I think that I probably have more care than maybe a 20-year-old kid that I would otherwise hire to come in and answer the phone for you guys, right? And that's been a big value proposition for those of you that have worked with me, those that have produced with me, those that have helped us get to $50 million. So I want to do it smartly, and I want to stay connected with the field. So we'll continue to grow, and we'll continue to grow smart. But in the meantime, thank you for the $50 million. Let's get to $70 million next year. Again, smart. Not $100 million next year, but maybe $70 million. Number two, swift term with Symetra. Symetra has an accelerated underwriting process. Well, an accelerated process, not just underwriting. And I'm telling you that if you hate the process of life insurance, talk with me about their Swift term policy. There are policies being issued within a matter of minutes, rather a matter of hours. Well, is their term good from a price standpoint? It is usually within the top 5 of the term ledgers that I run. And you will find that here's a problem that I have with it that I think you would appreciate. The problem that I have with it is we manage the cases, the life insurance cases that come into our door, right? Any requirements that are outstanding. So an app comes in with, say, Protective, for instance, we punch it into our CRM, which is Smart Office, and then we follow it through the pipeline. Well, many times, by the time the term case with Symetra comes into our door and we see the application, we're calling out a day or two later, and the case is basically not non-existent from a pending policy standpoint. Why is that? So that's confusing from a system standpoint when you're looking at it. The system says pending, but it's not at Symetra. Dude, they're issuing the policies so fast that we don't even have time to manage what otherwise would be requirements with other carriers. So I thought you would appreciate that little problem that I have on the CG Financial Group side. That's a huge testament to just how fast these Swift term policies are being issued. So from a product standpoint and my second bullet point standpoint, Swift term, talk with me about that. And by the way, great convertibility privileges, actually the best convertibility privileges of any of the carriers that we have to their permanent products. Number 3, Corebridge annuities. They currently have a cap on their S&P 500, plain vanilla S&P 500 strategy, 12.25%. An agent asked me the other day, how do you sell this? Can you just give me your little spiel on how you sell it? And many of you have seen this a million times. It's simple. Mrs. Client, let's say that the market does one of these things. It goes down 20% and back up 25%, right? I draw it on a piece of paper. If you're in that market, you'd be back to where you started. You would merely be back to where you started. Negative 20, positive 25 equals 0. Negative 50, positive 100 equals 0. Well, what if you were in this that has what is called a cap of 12.25%? Year 1, and I'll draw a dotted line, you didn't go down, just a dotted line. You have all of your $100,000, no fees. Year 2, what happens when that market increases 25%? That dotted line goes up 12 and a quarter. Nobody has ever disagreed or balked at me when I said 12 and a quarter in the up years. That's as simple as the AIG, the Corebridge, formerly AIG. That's as simple as the product is. Or just so you guys and gals know, then we'll get on with the program here. They have a performance trigger, which means heads, you win, tails, you don't lose. What do I mean by that? I mean, when the market is up, any percentage, as the market has been 73 or 4% of the time throughout history, when the market is up, any percentage, you get 9.35%, period. Market's up 1%, you get 9.35%. The market's up 20%, you get 9.35%. What happens if the market is down? 0. That's called their performance trigger strategy, and it is selling like crazy. I don't know which one I like better, that one or the cap strategy. But you figure when the market goes up, it's not always going to go up 12 and a quarter. It's not always going to go up 9.35. But with the performance trigger, you get 9.35. So 2 strategies there with Corebridge from an accumulation standpoint. From an income standpoint, Athene. Athene is killing it. 30% benefit-based bonus. You put in 100 grand, turns into 130 grand. And then every year thereafter, it increases by 12% simple, at least for the first 10 years. But as I just wrote about, by the way, in my Broker World article that you'll see next month, that's all just funny money, right? People come to me. So I'll speak out of the other side of my mouth, and then I'll tell you the ultimate punchline here. People come to me and they say, oh, this company has a 20% roll-up, Charlie. Do you have this product? Well, I do have that product, but I'm going to run you an annuity rate watch ledger that shows you what is important. This little, 20% roll-ups and then the times the payout factor, none of that stuff matters. other than the end result of that calculation. And that is the ultimate payout that you're guaranteed for life, whenever it is that your client wants to take it. So I'll run you a ledger. Here are the carriers ranked in order, and your 20% roll up pales in comparison to the 10% roll-ups, the 7% roll-ups, the 12% roll-ups. And I'm just using an example. I'm just pulling examples out of the air here. Why is that? Because it's the entire calculation that matters and just the end result that really, really matters. So my point is although all of that 30% plus 12% and that is just kind of funny money, Athene, the end result, they are killing it. They and American Equity today, from an income standpoint, the end total amount of payout, they're the top of the industry right now. And lastly, bullet point number 4. I think I've gone through like 80 bullet points, but I'll just say bullet point number 4 here on my list. Register for our agent portal. All these articles that you see in my emails, all of the videos, all the little words of wisdom stuff, that is out there on my portal. So that portal has a couple hundred articles, a couple hundred videos. If you haven't registered, at www.cgfinancialgroup, LLC, don't forget that LLC.com, make sure you register for the agent portal. That's how you get all of that information that you see on LinkedIn, if you're on social media with me, on YouTube, if you're on YouTube with me, or in the emails, if you get the emails, which probably most of you do. And by the way, join our Facebook page, and that is CGFG for financial professionals, CGFG for financial professionals. So CG Financial Group, the acronym CGFG for financial professionals. You'll see that beautiful green little egg out there, but go ahead and follow that page because I post news out there, because I'm fully cognizant not everybody opens their emails. Many times they open social media before they open their emails. So a quick debrief of what we talked about last time. Discussed how estate planning is also about minimizing not just estate taxes, but income taxes, right? Capital gains taxes. When we talk about different ownership structures and what happens when one person passes an asset to another person because of death, there are all kinds of things that happen. Question for you folks. So this is where you start to participate, as I like to have you do. So a non-qualified annuity that has a gain of $100,000, let's say, you put in $100,000, it's worth $200,000. That person passes away. What does the beneficiary of that annuity have to pay in taxes? Or what is the amount that is taxable to that beneficiary? So remember, they put in $100,000, it's worth $200,000, that person passes away. It's a non-qualified annuity, so the question is what is taxed to the beneficiary of that annuity, which is a part of the estate, right? So what is taxed to the beneficiary of that annuity? The answer to that question is the gain, yes, which is $100,000, right? So a part of estate planning is also about minimizing that. How can we minimize that? By the way, folks, does the non-qualified stretch still exist today? Yes, it does. It does. The non-qualified stretch has not been, what would I say, decimated like the qualified stretch has been. So that non-qualified stretch, a part of estate planning, which we didn't go into last time, is, hey, what are your options of spreading out that $100,000 tax liability, which is the gain? What are your options here? Well, the beneficiary can spread it out over their lifetime, right? So my point to all this is we talked about income tax rates, which is annuities and certificates of deposit, life insurance, if the life insurance is a modified endowment contract, for example. Also, capital gains taxes. So when you put this amount of money into a security, let's say, but that security is now worth that much, when you pass away, and that goes to a beneficiary, generally securities have stepped up cost basis, right? What does that mean? It means on the day that you die, that higher value is what that beneficiary has been deemed to have as a cost basis in it. Why does that matter? So that if they turn around and sell it, that high cost basis means very little taxation, right? So as a part of estate taxes, you have to know, or as a part of estate planning, you have to know all of these other taxes. So we went over there as a review, over that as a review. We went over the historic exemption amounts. You know, if you go back to what was it, like 2010, and I'm here in Iowa. I remember when the estate tax, which is unified with the lifetime gift tax exemption, the unified credit, they call it, um, estate taxes and a gift taxes from an exemption standpoint are the same, meaning, hey, whether you give it away during your lifetime or you pass away with it, you're allowed a certain exemption amount. We went over that last week, but I remember when, think of Iowa. How much does one of those big combines cost? Those combines out in the field that are picking the corn. And you East Coasters and West Coasters are probably like, a what? A combine? What's a combine? You look at these farmers out here in Iowa and you may think, oh yeah, they're farmers wearing bib overalls with mud all over them, driving that combine. I'm driving a Bentley, right? They're driving a combine. I would take the combine over a Bentley any day. What, combines today are like $1 million out there driving around in the field. So anyway, the state tax exemption back in like 2010 or whatever was around a million five or something like that. I don't remember when it was, but let's just say it was $1.5 million. It was somewhere around 2010 because I remember giving presentations on this. So let's see. So you have one combine, and then you have farmland worth maybe another. Let's just be conservative and say another $1 million, right? So you have $2 million. That person passed away with a $2 million estate, which means the estate tax exemption of 1.5. That meant that $500,000 was going to be subject to estate taxes of 40, whatever it was back then. Let's say 40%, which is what it is today. So that means think of the estate. You just have these two assets. You have farmland. Is farmland very liquid? You have a combine. Is a combine a tractor? Let's just call it a tractor for the East and West Coast folks. You have a tractor that's worth $1 million. Is that very liquid? But yet you have let's see, $500,000 times 40%. That's a $200,000 estate tax bill. Folks, what needs to happen to that family? You tell me, how do they pay the government, which needs to be done within 9 months, of that person passing away? What needs to happen? You need to come up with cash. How do you come up with cash? Well, then you have to fire sale it. Hey, can you please, please, please buy my land? Can you please, please, please buy this combine? When the seller is saying, please, 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 that means that it is a buyer's market for that particular transaction. So not optimal. So we talked about that. We talked about the way to leverage 2026 by giving away stuff right now. Also, during your lifetime, there are ways. What do we have here? Couple said, yep, you have to come up with cash. Life insurance. Yeah, what I just explained there, let's just simplify this and say a life insurance policy was there on Billy, the farmer, right, on his life. So when he passed away and that $200,000 estate tax came due, when it came due, you had something that paid that out immediately. But folks, I'll take this a step further. So kind of stream of thought here as we have a discussion on estate taxes. What happens if Billy the farmer, Bubba the farmer, Charlie the farmer actually owned that $200,000 life insurance policy? When he passed away, what happens to that in addition to everything else that we're talking about, what happens to the value of that $200,000 life insurance policy? So you have this circular formula, right? It is also included in the estate. So we've just made our issue worse. Okay, well, now he has additional estate taxes on the $200,000 life insurance. Yes, that's right. If the person that passes away owned the life insurance policy, that's included in the estate. Doesn't matter who the insured is. If I have a $5 million policy on you, you're the insured, and I'm the owner of that $5 million policy, you pass away, guess what would be included in, I'm sorry. If you have a $5 million policy that you're insured on, and I am the owner of that, and I pass away, guess what's included in my estate? It's not the entire $5 million. It's a calculation, the reserves of the policy basically, but it's about the owner, not the insured. But I digress there. So we have this 200,000 that's added to it. Wouldn't that make sense to have a separate entity instead of Billy Bob owning that policy? That separate entity owns that policy. That can be called an irrevocable life insurance trust. But we talked about ways here to where you can remove assets from the estate without using up that exemption, and that is the annual exclusion amount. So in 2024, it's 18,000 bucks. Meaning, remember what I just said, whether in life or after death, you have today $13.6 million of exemption, period. If you give away 10 million today, you only have $3.6 million left over. So after you die, whatever's above and beyond that, that's taxed, whether in life or after death. But what doesn't subtract from that exemption, period, what doesn't subtract from that exemption is an annual exclusion amount. So I have 2 kids. I can give $36,000 to both of them, 18,000, 18,000. That doesn't reduce my exemption. Me and my wife, between the two of us, we can give away $72,000, right? 18,000 each of them, each of us giving that to them. So that's where that annual exclusion really comes into play. And then I did an irrevocable life insurance trust example here to where an islet was owned by, well, the trust. And I never got to make a couple points on this irrevocable life insurance trust. We came up to the end pretty darn quick, as we will in this one. Actually, we have plenty of time on this one. So I promise you, I'm not just droning along here. I want to give context. Here is what I said. I said that this $4 million liability, estate tax liability that was going to happen, that can be taken care of by an irrevocable life insurance trust that Jack and Jill will grant to, grantors of a trust. That is, they're not the trustees of the trust, but they're the grantors of the trust. So the trust is going to own a life insurance policy. It can't be Jack. It can't be Jill. Why is that? Because of what I just explained. We want a separate entity owning this. Not a revocable trust, but it has to be an irrevocable trust, right? A revocable trust, it's just like Jack and Jill would have owned it. An irrevocable trust is a completely separate entity, a completely separate tax identification number. So it's completely separate. But what if Jack and Jill paid premiums into the policy that's owned by the irrevocable life insurance trust, which has 4 beneficiaries in it, and the amount of premium was below what their annual exclusions are? Remember I said $18,000? So the amount of premium that they put into it, which is $102,000, but if you divide that up, 4 different beneficiaries, there's 2 of them, it's less than the $18,000 each of them can put into that trust for each of the beneficiaries. So they're contributing $102,000 to the trust. The trustees turn around paying the premium, the $102,000 premium on the life insurance policy that's owned by the islet. When they pass away on this second to die policy, what happens? That $4 million is going to pay for, or can be used to pay for, the estate taxes that'll happen at that point in time. Couple things, crummy powers. And it's not just about the crummy letters, crummy powers. Here is a concept when it comes to gifting property. If I give you a piece of property and say, hey, you can't use it right now, but you can use it 20 years from now. But that property is $18,000. Does the IRS say that that is a gift, so to speak? To you, it's not really a gift, right? To you, it's not really a gift because I'm saying you can use this 100 years from now. To you, it's not a gift. Well, to the IRS, they also say that it's not a gift, at least in regards to using that annual exclusion, that $18,000 annual exclusion. Why is that? Well, you can imagine the trickery that would happen to where you're not really gifting anything to somebody, but yet you can use that $18,000 exclusion. Imagine the trickery that would happen, people trying to remove assets from their estates. So The IRS is a step ahead of us, or Congress is a step ahead of us, and say, no, in order for that to be a true gift to where you can use the annual exclusion, it has to be a gift of present interest, meaning that that person can use it now. But folks, let me ask you a question. So gifting money into a trust that is ultimately not going to be given to beneficiaries for a gazillion years, tell me, is that a gift of, is that just by itself with what I just explained, is that a gift of present interest to where that $18,000 can be utilized as the exclusion to where that $18,000 isn't reduced from their exemption? Is that a gift of present interest? Just by me saying, here, trust, here's 18,000, the beneficiaries of the trust won't be able to use it until I die 30 years from now. With what I just explained, is that a gift of present interest, which is what's required to get that $18,000 exclusion? The answer to that question is heck no, it's not. So what you'll see if you're around trusts long enough. So how do we do this, Charlie? Then what you just, all this is crap then? No, because let me get to it. If you've been around trusts long enough, specifically irrevocable life insurance trusts, which is one of the foremost tools in estate planning when it comes to estate taxes, is crummy provisions, crummy powers, crummy letters. And the concept is this, is the trustee of the trust, and I have a family member who's a trustee of a trust, but oh gee, I forgot to send out the crummy letters. I'm like, that's pretty serious. You have to do those every year. It's not a client of mine, it's a family member, but what are those crummy letters? So what the IRS has said is, hey, you have to give the beneficiaries of that trust at least an option of using what you contributed to the trust to where they can cash it out right now. That $18,000 and technically parts of the policy, I believe, kind of irrelevant right now. But you can give them access within like a 30-day period of time on an annual basis after they receive that letter. They have like a 30-day period of time to where they can get access to those funds. Now, when those letters go out, I think it's pretty darn important that the beneficiaries realize I'm really not supposed to take money out of it, but we have the formality here to turn this future interest gift into a present interest gift by me at least being presented with the option to cash it out. Does anybody cash it out? No, they don't. I mean, if they do, then that blows up the ability to use the annual exclusion there. And that's all that I have on that. So let's get into probate. Any questions before we go here? Why does it have to be a second to die policy? That's a great question. Why did we talk about a second to die policy? Because in that example, it was spouses, right? Husband and wife. This is a great question. Cover things that I didn't talk about. If I pass away and I have an estate worth 30 million bucks, let's say, does my wife have an estate tax in that year, folks? If I pass away, the first to die, if I pass away first, does my wife have an estate tax on 30 million bucks or the excess? No. So that's kind of your first clue, right? Why? Because you have the unlimited marital deduction. Basically, she gets all of that tax free. But eventually those chickens are coming home to roost, right? And that is after her death. So a couple reasons why the second to die, because the state taxes in that example aren't going to kick in until after her death. I love you. That's one of the oddest messages I've ever seen. I love you. Thanks, Gary. Oh, a couple other questions here. Bump up of estate Sal. Okay, sorry, I wasn't looking. I was looking at Q&A or I wasn't looking at Q&A cash. That's the Swift term have living benefits. For the most part, no, not the living benefits that we're talking about. So as you can see, I was behind in my answering the questions. So two reasons primarily, second to die over first to die. And first to die are used a lot with irrevocable trust. But in this example, the state tax liability isn't going to happen until she dies. But number two is, I lost my train of thought. Number two is, what was I going to say? Oh, just cheapness of coverage. You know, you can get a large death, a $4 million death benefit for a lot cheaper on a second to die than what you otherwise could have a first to die. Some people are like, well, why would you not get life insurance policies on both of them, him and her? Well, because when he dies, we're just we're making the problem bigger by her having a larger estate at that point in time. So yeah, great question. Any other questions, bring them up. So here's a process of probate, and I'm also going to get into what the process is. So this is a process that is administered by the court. So you pass away, and the process is administered by the court because creditors of the estate, as well as beneficiaries of the estate, or heirs of the estate, I should say, need to be protected. Imagine if you're a creditor and if you lent money to people, and when those people passed away with their 30-year mortgage or whatever, imagine if there was not any kind of a process for of that person's estate to pay off the mortgage that you gave that person. Imagine if there was no such thing as probate. Just, hey, I'm hoping and praying you don't die, because if you do die, because probate doesn't exist, your heirs of your estate are going to take off and not worry about the debt. Well, courts need to get involved for creditors, right? That is probate. Courts need to get involved for the beneficiaries of the state, the heirs of a state. Why? Because I'll say this, I dealt with this with my dad. We had a bull in the china shop, right? Bull in the china shop. Just walk in, let's grab this, let's grab that. Oh, this is a couple $1,000 here. Guns and everything, right? Imagine if we did not have a court process where checks and balances needed to be followed. It'd be cage matches, right? Hey, I'm going to fight you for that, and the toughest one wins. You know, the beneficiary is doing that. So that is the process. That is the reason for probate. And a will, let me ask you a question. Does a will avoid probate? A lot of people think that wills avoid probate. Do wills avoid probate? No, we have a lot of no's there. Wills absolutely do not avoid probate. Wills are merely just a roadmap for the judges as well as the attorneys. Now, what if you die without a will? What is that called? As my dad did, I'll tell you, my dad died without a will. This was back in 2006. And I'm like, well, looks like we get to check out the Iowa state intestacy laws now. You know, it's interesting. I've been in finance for 25 years, but sometimes my family doesn't listen to me because, well, just whatever. But should have had a will, right? So intestacy laws. So there is no roadmap, nothing. It's just, okay, so you have Charlie Gipple Sr. here, and then the first order of business is there a spouse? Which there wasn't at the time. Okay, then it goes to the kids. If there aren't any kids present, which there were, then it goes back up. Are there parents to Charlie Gipple Sr.? There weren't, and then it goes out, if I remember. So what I just laid out there are kind of the things that state intestacy laws lay out. Okay, we have no will telling us where everything is going to go to. Even if we did have a will, we're going to deliberate on it for 6 months, 7 months, 8 months, 10 months, up to 3 years in Iowa. But now that we don't have a will, well, then we got to do one of these things. All right, are there kids? So that's the process of probate. Well, we haven't gotten into the full process of probate, but what is probate property? So in estate planning, and I learned a lot about estate planning through my CFP process. The CFP process, they said, okay, you have, UMD, unlimited marital deduction. That's what he meant by I love you. Yeah. Unlimited marital deduction basically means, yes, I love you because you get all of the assets as the spouse without taxes. So what is probate? What is a probate estate? What are probate assets? So through my CFP process, they would drill us on, okay, what's a probate estate? What is a gross estate? So folks, let me ask you a question. Are annuities generally included in the probate estate? Are annuities generally included in the probate estate? No, right? So the probate estate is all these assets that go through probate. Well, that's where the judges and the attorneys who get paid a good amount of money, and that money has to come from somewhere, which we'll get into, they determine where those assets go. If there's a will, then that's good. There are beneficiaries on annuities. They're not a part of the probate estate. Folks, are annuities a part of the gross estate? And then I'll define that as well. Are annuities generally a part of the gross estate? Yes. So through the CFP process, you learn to pay attention to words. Oh, probate estate. Oh, gross estate. I mean, sounds the same, right? But you learn that there's a big difference. These two areas, gross estate is the top of the calculations for estate taxes. Well, annuities plus any cash that was laying around. Just because you avoid probate doesn't mean that that asset is excluded from one's estate. What are assets that are excluded from the estate? Well, assets owned by an irrevocable trust, for example, right? So through estate planning, and the more that you guys and gals drill into estate planning, as many of you already know that have drilled into estate planning, probate estate and gross estate are two terms that are widely used. Gross estate, usually only if there's an estate tax issue there, which, as we said, not many have. Let's see. So what is probate property? Let's see. If I owned my house, for example, solely in my name, and I passed away, that would be probate property. And we'll get into TODs and PODs, transfers on death, payable on death. Can I effectively put a beneficiary on my house? Sal, my real estate guy. Sal knows more about real estate than he's probably forgotten more about real estate than I'll ever know. But can I put a TOD or POD, payable on death, a beneficiary basically on my real estate? In Iowa, I can. In Iowa, I can. Not in all states. Yes, ladybird deed. That's right. I don't know why they call it. I never looked into why they call it a ladybird deed, but yeah, you can put that on the deed to where it transfers to my spouse at death, for example. But if I didn't have that, that would be a part of probate property. Tenants in common. So in asset protection, there are a lot of webinars given, and I give these asset protection, where we talk about joint with rights of survivorship, for example, tenants in common. So these are both ways to own property, right? Joint with rights of survivorship. That's obvious. Does that avoid probate? With rights of survivorship? Yeah, boom, it goes on to the other people owning that property, joint with rights of survivorship. That obviously avoids probate. However, what if me and just some kind of quasi stranger get together, drinks at a bar, and we say, you know what? Let's each go halvesies, which is famous last words. Well, famous last words are you met them in a bar and then you decide to partner. There are a lot of famous last words there. Let's go halvesies on this rental property down in Sun Valley. It's a $1 million property. Let's each put in $500,000 and let's rent that sucker out. How might we own that property? Well, I know that if I die, I want my chunk to go to my beneficiaries, right? I don't want that to go to him. So I don't want it joint with rights of survivorship. Well, then I would choose tenants in common, tenants in common. And that's what that second bullet point is referring to, tenants in common. Does that avoid probate? Generally, no. Generally, my chunk, when I die, that guy, the bar guy, still has his half of the property. What about my half? It goes through probate, and ultimately the probate courts will realize that probably my wife is the new owner of that half of the property. It's a matter of public record. We'll get into the process here, but it's very much a matter of public record. You sent out a notice in the newspaper, hey, creditors, Charlie Gipple died. Come and get your money if he owes you money, as well as just the courts have it all on record. So let's go through the probate process, then we'll get into the documents here. The perfect estate plan, so to speak. First of all, you hire an attorney. In the state of Iowa, anyway, you have to be working with a licensed attorney to go through the probate process. So somebody passes away, you contact an attorney immediately. What does that attorney do? Well, that attorney files a petition to the courts to open up a probate estate. And that's where if there's a will, you file that with the court so that ultimately the judge, the attorney can look at that will. And as we work to distribute the property, got a lot of questions here. All right, Ladybird, a lot of people educating us on the Ladybird deed. A lot of folks. LBJ, Lyndon B. Johnson's and Lady Bird Johnson's names illustrate the example. All right, so yeah, given an explanation on the Lady Bird deed, which I'll read once we get offline here. But thank you, folks, and keep that coming. If you know something that I don't know, educate me, because I read all these comments at the end. I read all the evaluations, all that stuff. So please keep contributing. If I don't get to it, it's only because, well, I have ADD, so therefore I can't do 3 things at once. I don't really have ADD, but sometimes I feel like it. The newspaper. So in Iowa, the creditors have 4 months after, I think it's after there's an article published in the newspaper, and that's a notice of petition for probate. There's a section in the newspaper that says, the estate of Charlie Gipple, if Charlie Gipple's estate owes any money to you, you have 4 months. So think of this, at least 4 months just in this little component here that the estate has to be left open, just so the creditors can come back and say, yeah, he owes us a mortgage of $100,000 or whatever like that, right? So I talked about the gross estate. The gross estate is, hey, what's the value of the estate up here? But then as we go down the estate calculations, a part of that would be reducing the gross estate by the debts that person owes, which is in Iowa, a 4-month period of time. Let's see, if my client inherits a piece of property that was not in a trust, do they pay taxes on the current value of the property? They are now on the deed. Great question, folks. Can you answer his question? And then I'll answer it. If my client inherits a piece of property that was not in a trust, do they pay taxes on the current value of the property? They are now on the deed. So I think the question could be one of 2 different things. First of all, if your client, if there are estate taxes at play, it is the estate that takes care of the estate taxes. Now, I would venture to guess this is not an estate tax issue, but correct me if I'm wrong. So if somebody passed away with $10 million of an estate, the exemption is $7 million, then yeah, there are estate taxes due on the $3 million excess. But your client who inherits that property is not responsible for the estate taxes. Who is responsible for the estate taxes? The estate is responsible for the estate taxes, even though your client is the one that got the property. Now, I think what you're asking about, and I get this a lot with gifts. Okay, Charlie, so if I get a gift from my mom of $100,000, do I have to pay a gift tax this year? Does my mom have to pay a gift tax? Almost nobody, not that person or this person, almost nobody ever pays gift taxes. Why is that? Well, again, because remember, if it's above the $18,000, then whatever the excess is, it just reduces their lifetime exemption amount. So usually nobody pays gift taxes. Now, in that same vein, I think what you're asking about is, so they just got a property, the value of the property, it's a $200,000 property. My client doesn't pay any taxes on that property. Real estate, for example, generally no. I mean, if it's real estate, that person has a $200,000 property now. There are no taxes that person will owe. Now, if that person turns around and sells that property, real estate folks, let's say that person turns around and sells that property for $200,000. And by the way, the original cost basis was only $100,000. So that person turns around and sells that property for $200,000, which was also the value at the day of death. What is generally the capital gains tax liability on that property when that person turns around to sell it, say 6 months from now? None. None. Why is that? Because of what I just explained, because certain properties have, and securities generally have stepped up cost basis. So what we're getting at there, if my client inherits a piece of property, so somebody died with that property, which means there is probably a stepped up cost basis. $200,000 is the value today. That new cost basis is 200,000. They turn around and sell it for 200,000. They have no tax liability. They turn around and sell it for $300,000. You're talking a capital gains tax liability there. Don't want to get a whole lot into short-term capital gains, long-term capital gains. But yeah, just by virtue of inheriting the property, generally no taxes paid by your client in that case. So we have the newspaper. Hey, Charlie Gipple died. Come and get it. Come and get your money. Asset and liability inventory. Think of this. You know, my dad owned a construction business, a pretty darn successful construction business. Underground utilities, so water lines, sewer lines. This is how I grew up, digging ditches, right? Water lines, sewer lines, pouring concrete as well. Those were some of the best days of my life. My hands got all big and callousy at the time, but think of all of the suppliers that he owed money to, right? Pipe suppliers, concrete suppliers, a concrete company there in town. Think of, well, think of all the people that owed him money. I'm sure we didn't get anywhere near everything that was outstanding from an accounts receivable standpoint. The assets, you had backhoes, you had skid loaders, you have underground drilling rods, you know. If you've ever seen any of those directional drilling machines, you probably don't know what they are, but you see a machine set up on the corner of a road, and then about 100 yards down, there's a hole dug. What are they doing? What they're doing is they're drilling down under there, and the drill bit is popping up on the other side. And then what they do is they attach the pipe on the other end and then pull it back through without ever digging a trench. How much does all of that, and I'm getting off base here, how much does all that stuff cost? A gazillion bucks, right? So imagine the process that we went through, right? But then after all the creditors have been paid off, which, you know, that 4-month window alone, I mean, so now we're talking what, 6 months, 7 months, 8 months, 9 months, up to 3 years in Iowa. And forget the hassle, look at the cost. So as a client sits there and says, okay, Sal, so you're telling me that you work with a estate planning attorney, and that he's going to charge me a whopping $2,000 for a revocable trust. Wow, that's ridiculous. That $2,000, or maybe it's 1,000 or 1,500, depending on where you, for a revocable trust. That is absolutely ridiculous. Really? When the cost of probate, because of those lawyers and judges here in Iowa, if you have $100,000 estate, granted, for smaller estates, there's kind of an expedited process that you can go through. But $100,000 estate, $5,000 in just attorney's fees, you know, probate fees, $1 million estate, $20,000 to $50,000 in probate fees. Please give me that revocable trust, and I will gladly pay my $2,000. So that's probate. Does that make sense to everybody? Did I miss anything in the probate process? And that's an article coming out in Broker World next month, to give a quick plug on that. All right, 2 questions for the group. Do wills avoid probate? We already answered that. What about this? Sal is salivating over this one, especially the real estate folks. What is ancillary probate? What is ancillary probate, somebody? So when you think of probate, it's a state specific thing, right? In Iowa, you know, you open up a probate in the state of Iowa. So when you think of ancillary probate, what am I referring to there? Yep. Property in other states. Oh, my probate, you know, my probate process, it'll be easy. I have a will, which still means it's going to go through probate. Oh, but it'll be easy, right? Should be easy and fairly harmless. Well, do you have property in other states? You know, like a lot of folks here in Iowa. One of my top clients has, I think, three houses, right? One is down in Florida. You can bet if he passes away, if he does not have something like a revocable trust, there's going to be ancillary probate, as in a probate opened up in Iowa and a probate opened up in the state of Florida. Why? Because in Florida, I don't even know. Sal, you would know. You're in Florida. I don't even know if it has a TOD, a POD on the deed down there. But chances are he's going to need to open up a probate estate down in Florida because, well, he's got property in Florida and wills are probate, I should say, is state specific. So just keep that in mind for people that have assets spread across a lot of things. All right, so documents. We've talked ad nauseum what a will is. Generally, so I have a family member. Oh, my will. It's in my sock drawer. Um, really? So you just wrote it out? Yeah, I just wrote it out. Probably for this family, it wouldn't be an issue because they all get along. But if you have siblings or whatever that like to fight, is that will really valid? Well, in Iowa, just writing something on a piece of paper, throwing it in a sock drawer isn't enough. You have to have two witnesses. It's also got to be notarized, right? A will, what else does a will do? Me with not so small kids, my 6'6", 16-year-old and my probably 6 foot tall 13-year-old, but let's just say young kids. If I die, who's the guardian for my kids? That's wills are important in that regard, right? Otherwise, if you die without a will, which is called, what's it called, folks? If you die without a will, intestate, that's right, then who decides who the guardian of your child is going to be? Who decides that? The court. The courts decide that. I don't want that to happen. So wills are important, but I'll get into some good alternatives here. By the way, in Iowa, you have conservatorships. Remember Britney Spears, the conservatorship? And you have guardianships. Guardianships, at least here in Iowa, refer to taking care, health care and all that, as well as, well, think of guarding the kids. Conservatorships have more to do with the money side of things. Guardianships, health care, well-being. Conservatorship, at least here in Iowa, conservatorships, it has more to do with money. By the way, if Britney Spears, right, who was basically held captive by her dad because she was ruled as mentally incompetent or whatever it was, which means then that goes to a court proceeding. A lot like if you have somebody who has severe dementia, they can't take care of themselves or making bad judgments. The family can file for a conservatorship, which is a big, long court process, which is what we're talking about here with my kids if I died without a will. And because they are legally incompetent, a lot like Britney Spears was, basically that conservatorship means that somebody else, not you, has control over your money, right? Would that have been avoided, folks? What document might possibly, and I know very little about the Britney Spears thing, so I'm probably talking remiss here, but I think I'm guessing probably fairly accurate. What document, if she had, might have prevented her father, who I think she was fairly estranged with, right? What might have prevented him as being the person that controlled her money at that point in time? What document is it that I am referring to there? An UTMA? Not really, because that's more for minors. This is a tough one here. A POA, not just a POA, not just a power of attorney, but what type of power of attorney? And we're going to get to this document here in a bit. What type of power of attorney? Boom, a durable power of attorney. Yes, let's get to durable power of attorneys first here. So here is so I heard this attorney giving a webinar the other day, the perfect estate plan. And she said, number one, you got to have a will. Number two is a living will. So advanced directives are a group of other documents, right? So say, for instance, living wills. Living will is, how do you want to be taken care of in your final days effectively? Now, states have some weird provisions with living wills. as in, doctors need to be able to look at something and know 100% that it's going to hold up in court if they pull the plug on somebody. So naturally, a lot of regulations around living wills. So people will say, well, as a part of this group of advanced directives, what about a healthcare power of attorney that says that somebody else can make the decisions? So healthcare directives or advanced directives are a group of a set of other documents like living wills, advanced healthcare directives, healthcare power of attorneys. I usually just say, hey, advanced healthcare directive, talk with an attorney which documents are best. That will take care of the client's end of life issues. Do you pull the plug? Do you keep them on life support? All that stuff. So that's the second part that this attorney said is the perfect estate plan. And then I'm going to say, yeah, but here in a bit. Durable power of attorney. What makes a power of attorney durable? So that once you become incompetent, right? Once you lose your mind, which unfortunately some of us will, and it kind of runs in my family a little bit. So if I ever start acting funky, you know that I'm there. A durable power of attorney withstands you dementia. So today, my wife, durable power of attorney, right? A normal power of attorney, a non-durable power of attorney says, oh, Charlie's incompetent, boom, no more power of attorney. Well, I would argue that that's the most important reason to have a power of attorney. So then make it a durable power of attorney so that at that point in time, my wife can make the financial decisions that I cannot make. You can have springing power of attorneys to where I don't want anybody to control my stuff until it's time, until I lose my mind there. That's when I want people to be able to make decisions for me. So power of attorneys, that's the financial stuff. The healthcare power of attorneys obviously has to do with healthcare related decisions. And there are also other things, limited power of attorneys. I've helped folks qualify for Medicaid. I've helped folks qualify for Medicaid, and running down statements, it's crazy. What I can do is I can have my attorney draft a limited power of attorney, limited in that all that Charlie can do for this person is fetch the statements from all these different companies where they have assets, because we need to collect assets to qualify for Medicaid. A limited power of attorney, but I can only do that. The attorney drafts that up. I go to American Funds or whatever and say, yeah, you got to give me information on him, but I can't do anything else other than that. A general power of attorney is completely different than that, in that I can trade on his behalf and all that. So like anything else, there are a lot of POAs. The revocable trust. I would argue for most clients, forget this will, not forget, well, let me move on here. Revocable trust, but then a pour over will. I would argue to forget the will in many cases, and these 4 documents at the bottom are the perfect estate plan for most folks. Now, the perfect estate plan for somebody that has 15 million bucks in assets is completely different than this, right? Somebody that maybe has a kid with special needs trust, right? But in general, you forget the will, right? You have the healthcare, the advanced healthcare directive, or the advanced directives, whatever group it is that your attorney thinks is feasible. The durable power of attorney, financial decisions after you become incompetent. The revocable trust, the foundation of all of this, that will generally own property that would be subject to probate. What those trusts say is, hey, when I pass away, this property that is owned by Charlie Gipple Revocable Trust goes to this person, this person, this person. That doesn't go through probate court at all. It avoids probate. Revocable trusts turn into irrevocable trusts after you pass away. Why? Because nobody can change it after you pass away. Those assets go to each person, however the trust sees fit. What is a pour over will? Remember what I said about wills and guardians, specifying guardians. That's a part of the pour over will. But most important, or just as importantly, what happens on the day that you die? You stopped at the grocery store and bought a lottery ticket. And that lottery ticket was good. You have you have $500 million coming to you. What happens to that $500 million? Well, naturally, it is going to go through probate, right? Because no trust owned it. It wasn't in a security that a trust owned, nothing. It's going to go through a probate. What the pour over will says is, hey, as this goes through probate, where we want that money to go ultimately, or whatever assets it is we're talking about that was excluded from the revocable trust. So there's stuff pouring away from the stuff that's excluded from the revocable trust, like this lottery ticket. We want it to be distributed per what the revocable trust says, albeit, yes, there will be probate on this chunk. We just want it to be distributed per what the revocable trust says. Those four documents, I would argue, in most cases, is the perfect estate plan. Your advance directive, your durable power of attorney, the foundation, revocable trust, and the pour over will. You know, folks, I'm not going to spend a ton of time on this because we're at the top of the hour, but methods of estate transfer. I'm going to talk a little more next in our series about rights of survivorship, community property states, stepped up cost basis, items like that. I was going to talk a little bit about it, but we're at the top of the hour. Folks, please fill out the evaluation. Tell me what you think. If you're not appointed with CG Financial Group and like this type of stuff, why aren't you appointed? And just remember, a lot of these companies, they do dual appointments. So that means you don't have to have that awkward conversation with your current IMO. They will set you up with an additional appointment through CG Financial Group. So here in about 10 seconds, the evaluation is going to pop up, and I appreciate all your time. Tell me how we did.